Larry Millett. A husband who did not want his wife to leave spent months paying strangers on the internet to cast spells on her. And when the spells did nothing, his requests began to change. He stopped asking for her love and started asking that she be kept from ever walking out the door. And on the very day his wife reached out to a divorce attorney, she disappeared. And to this day, her body has never been found. May Millett, known to almost everyone as Maya, was 39 years old and a mother of 3. She had been married for 20 years and had built her life in Chula Vista, a quiet community just south of San Diego. To the people who knew her, she was the steady center of her household, the kind of person whose absence would be noticed within hours. That is exactly why the alarm went up so quickly when she stopped answering her phone. Maya was last seen on January 7th, 2021, the same day she had contacted a lawyer about ending her marriage. When she could not be reached, her sister, Marie-Chris Drouaillet, reported her missing 2 days later, on January 9th. What investigators uncovered in the months that followed did not resemble any ordinary domestic case. According to trial testimony from a San Diego district attorney investigator named James Rhodes, Maya's husband, Larry Millett, had spent the previous months deep in an online world of paid spellcasters. Between the autumn of 2020 and that January, he spent just over $1,100 on roughly 70 separate spells and exchanged more than 1,000 messages with the people selling them. The lead spellcaster went by the name Mystic Lunar. What began as requests to keep Maya close soon shifted into something colder. Millett started asking that she be made unable to leave the house at all, telling one of them that it was time to stop being gentle. Every request carried a date and a timestamp. And together, they formed a record of a man growing more desperate as the woman he had married made her plans to go. Inside the family home, detectives later photographed what they described as an altar, and a vial recovered from the house tested positive for a substance derived from poison hemlock. But how do you prove a man committed a murder when there is no body, no crime scene, and no weapon to place in his hands? That was the case San Diego prosecutors chose to take on. And it is the kind of case that rarely reaches a courtroom at all, because a first-degree conviction without remains is one of the hardest results a prosecutor can win. Millett was named a person of interest in July of 2021 and arrested that October on the 19th. His trial did not begin until May of 2026, and it stretched across nearly 2 months in San Diego County Superior Court before Judge Enrique Camarena. Prosecutors called more than 60 witnesses and built the entire case on circumstantial and digital evidence. The messages, the spending, the timeline, and the complete absence of any trace of Maya after that January day. Piece by piece, they reassembled the private history of the marriage from the devices Millett had used. The defense argued that a case without a body was a case without proof, and that everything the state had offered was suggestion rather than certainty. The jury did not agree. After deliberating for under 6 hours, they found Larry Millett guilty of first-degree murder on July 9th, 2026. It was a verdict that rested almost entirely on words he had typed himself, in the belief that no one else would ever read them. Days later, on July 20th, he pleaded guilty to a separate charge involving an unregistered assault weapon that had been found during the investigation. As of the making of this video, Millett has been convicted but not yet sentenced. His sentencing on both counts is scheduled for September 29th, 2026, where he faces 25 years to life on the murder count, with the weapons charge carrying up to 3 additional years. His defense is expected to pursue post-trial motions and an appeal, a process that could take years to work through the courts. Maya has never been found. Her 3 children were left without their mother and her family, who had reported her missing within days and pressed for answers ever since, has continued the search for her, still hoping to bring her home. Investigators managed to build the timeline of her final day down to the hour, and yet the one thing they could never place was Maya herself. A conviction has answered the question of guilt. It has not answered the question of where she is, and until it does, the people who loved her are left with a verdict, but no place to grieve. That case turned on a scheme no one around Maya ever saw taking shape. The next one turned on a scheme that formed inside a single family, one its own members would later insist had begun as a joke. Tracy Grist. For nearly a year, a family in Utah told themselves that what they were discussing was not serious, that it was only talk. At the center of it sat a grandmother who was, by her family's own account, the one steering the plan. And when the plan finally became real, and a man lay dying in her home, she waited several minutes before she picked up the phone to call for help. Matthew Restelli was 42 years old and lived in California. He was a husband and a father, married to Tracy Grist's daughter, and by the summer of 2024, the relationship between him and his wife's family had grown deeply strained. He believed he was making the long drive to Utah for an ordinary reason, to collect his wife and their children. He had no way of knowing that the trip had been arranged for an entirely different purpose. On July 12, 2024, Matthew arrived at Grist's home in American Fork in Utah County. The prosecutor, Adam Pomeroy, would later describe Tracy Grist as the hub of the entire operation, the one directing it from the middle like mission control while others carried out the physical acts. To make certain Matthew could be followed on his journey, a small tracking tag had been hidden in his truck, monitoring him the whole way from California so the family would know exactly when he would arrive. Everything about that arrival had been prepared in advance, from the timing to the story that would greet him at the door. He was lured to the house on the promise of reuniting with his wife and children. Moments after he stepped inside, Grist's son, Kevin Ellis, shot him 7 times. Afterward, a knife was placed in Matthew's hand in an attempt to make the killing look like an act of self-defense, a staged detail meant to reverse the story of who had threatened whom. Grist herself waited roughly 8 minutes before contacting emergency services. Minutes that told investigators a great deal about how in control of the situation she was. Children were in the home at the time, a fact that would later form part of the charges against her. Could a plan this deliberate, this carefully staged, really have started as nothing more than a joke among family members? The courts did not treat it as one. Grist was arrested and charged in October of 2024 and entered a plea of not guilty the following June. The case against her family moved forward in pieces, each trial adding to the picture of a coordinated act rather than a single person's decision. Across those hearings, members of the family described how the idea had circulated among them for months, spoken of at times as a joke, until it hardened into something they were prepared to carry out. What had once been words became a rehearsal, and then an act. Her daughter, Matthew's wife, pleaded guilty and was sentenced to a term of up to life in September of 2025. Kevin Ellis, the man who fired the shots, was convicted in January of 2026 and sentenced that March on the 31st. Grist's own trial took place in Provo, in the 4th District Court, in April of 2026. On April 21st, a jury convicted her on every count she faced, including first-degree felony murder, conspiracy to commit murder, obstruction of justice, and 2 counts of domestic violence committed in the presence of a child. Each count reflected a different layer of the same afternoon. At her sentencing on June 10, 2026, Judge Roger Griffin handed down the maximum available to him, 15 years to life, along with consecutive terms on the remaining counts. He described the killing as one of the most senseless he had encountered in his years on the bench. And he told Grist plainly that he fully expected she would never be released from prison while she was alive, recommending that she never be considered for parole. No appeal has been reported, and given the consecutive terms stacked on top of the life sentence, any realistic chance of release is remote. All 3 family members are now imprisoned, their households scattered, and the children among them left to grow up in the wreckage of what the adults around them had set in motion. A man who drove north, believing he was going to pick up his wife and children instead, walked into a plan his own in-laws had spent months turning over among themselves. Whatever it may have started as, it ended as a coordinated killing. For the wider family, the reckoning did not land on one person alone. It fell on several, each answering separately for the same afternoon in American Fork. Grist's plot was intimate, hidden, and dressed up afterward to look like something it was not. The case that follows played out in the opposite way entirely, in the open on a public street, and it took the life of a man who was never even the intended target. Zoe Treadwell. In the middle of the night, on quiet residential streets in the south of England, a woman turned her Range Rover into a weapon and chased down electric bikes at speeds you would expect on a motorway. The man she killed was not the person she was hunting, and when she realized she had struck the wrong target, she did not stop. She paid for it to happen a second time. Joey Johnstone was 28 years old and rode an electric bike around Bournemouth on the Dorset coast. He was the partner of a woman named Sophie Quinn, and he was a father. On the night everything happened, he was simply out on his bike, moving through streets he knew well. He had no connection to the feud that was about to end his life, and no reason to think anyone on the road that night was looking for someone at all. The intended target was a man named Joshua Lovell, Zoe Treadwell's former partner, with whom she had been locked in a bitter and ongoing dispute. In the early hours of April 9th, 2025, Treadwell pursued electric bikes through the residential streets of South Kinson Drive in her Range Rover Evoque, reaching average speeds of between 66 and 75 miles per hour along roads never designed for anything close to that. The bikes were being ridden flat out ahead of her, weaving to escape, and in the darkness she struck and killed Joey Johnstone in what the court accepted was a case of mistaken identity. He was not the man she was after. A moment of confusion on a dark street had cost an innocent man his life. Yet rather than being stopped by the horror of what she had done, Treadwell arranged for the whole thing to happen again. On May 1st, 2025, having bought a Mercedes for a co-defendant named John J. Harrison, another deliberate collision was carried out on Kinson Road. That purchase mattered a great deal at trial, because it showed planning, money, and intent rather than a single loss of control. Lovell survived but suffered multiple fractures, and another man named Free Jenkins was left with life-changing injuries that included the partial amputation of a leg. These were not injuries anyone recovers from cleanly. One man would carry the loss of part of his leg for the rest of his life, a permanent mark left by a feud he was only caught at the edge of. The judge who oversaw the case, Mr. Justice Linden, stated plainly that Treadwell had used her car as a weapon. What kind of grudge drives a person to keep aiming a car at people even after it has already taken the life of a man who had nothing to do with the quarrel? That was the reality the jury at Winchester Crown Court had to weigh across a lengthy combined trial. Proceedings began on October 27th, 2025, covering the fatal collision, the second ramming, and the money and planning that tied them together into a single course of conduct. Investigators had reconstructed the routes and the speeds from the night of the fatal collision and tied them to the second attack through the very car Treadwell had bought for it, showing the jury that what happened had been a sustained course of conduct rather than a single terrible accident that ended when the first man died. On December 4th, the verdicts came back. Treadwell was convicted of murder, attempted murder, and grievous bodily harm with intent, while Harrison was convicted for his role in the second attack. On January 15th, 2026, Treadwell was sentenced at Winchester Crown Court to life imprisonment with a minimum term of 35 years. Harrison was jailed for 32 years. Because of the length of that minimum term, Treadwell will not even be eligible to apply for parole until she is around 71 years old, and even then release would be far from guaranteed. By the time that day arrives, the events of those 2 nights in the spring of 2025 will be more than 4 decades in the past. No appeal has been reported. She is now serving her life sentence, having taken the life of a stranger and then tried to finish what she started against the man she blamed. Joey Johnstone, meanwhile, was mourned as a partner and a father who had done nothing to invite any of it, killed by a grudge that was never even his. For Sophie Quinn and for their child, the loss was made harder still by the knowledge that he had simply been in the wrong place at the wrong moment, mistaken for a man he had never even met. Treadwell used a vehicle to settle a private feud, and a man who was never part of it paid the price. The next case also began with a car driven into people who never saw it coming. Except this time the victims were complete strangers, singled out for nothing more than who they were on what should have been one of the happiest mornings of the year. Anthony Gilheany. In the early hours of Christmas morning, a man who was drunk and banned from driving aimed his car at people making their way home through the heart of London. He struck 5 of them, and the court would later conclude that he chose some of his victims deliberately because of who they were and who they loved. Aidan Chapman was 25 years old. He was out in London's West End, the busy stretch of theaters and late-night crowds, when his life was upended by a stranger behind the wheel of a high-powered Mercedes. He was one of 5 people caught up in a series of attacks that unfolded across a handful of streets in the space of a short and violent stretch of time. He suffered catastrophic head injuries, and he would not survive them. The man responsible was Anthony Gilheany, a disqualified driver who left a nightclub in the early hours of December 25th, 2024. Instead of going home, he got behind the wheel of a powerful car he had no legal right to drive, and what followed moved through Shaftesbury Avenue, Archer Street, and Great Windmill Street, as he drove into one group of people after another. Witnesses described a car being used to pursue people rather than to get away, turning and coming back through the same few streets while people scattered onto the pavements to get clear. These are some of the most crowded streets in central London, still busy even in the small hours of a holiday, and that is what made the choice to use a car among them so dangerous. Prosecutors argued, and the court agreed, that some of those he targeted were chosen for reasons of racism and hostility toward their sexuality. He drove at a couple who were walking hand in hand, and he directed a racial slur at another man before assaulting him. This was not only reckless driving. It was, in the court's judgment, an attack aimed at particular people for who they were. The fact that Gilheany was already banned from driving only sharpened the recklessness, because he had chosen to take a fast, heavy car through crowds when the law had already told him he had no business being behind a wheel at all. 5 people were harmed across those streets that morning, Aidan Chapman, the most gravely hurt, was taken to hospital, where he fought for his life for nearly a week before he died on New Year's Eve, December 31st, 2024. The 4 others who were struck survived, but several were left with serious injuries and with the lasting fear that comes from being run down on an open street by someone who meant to do it. Gilheeney was arrested about 20 minutes after the attacks at Lincoln's Inn Fields. He was charged 2 days later on December 27th, and once Chapman died from his injuries, a murder charge was added in January of 2025. By then, what had begun as a reckless rampage had become a murder inquiry. How does an ordinary night out end with a car being driven straight at people whose only mistake was trying to get home? That was the case laid before a jury at the Old Bailey, one of the oldest and most serious criminal courts in the country. On December 19th, 2025, Gilheeney was convicted of murder, 2 counts of attempted murder, wounding with intent, and causing grievous bodily harm with intent. He was cleared of 1 further count of attempting to murder a 3rd man. But the weight of the remaining verdicts left little room for leniency. The court treated the racist and homophobic motivation as an aggravating feature of the sentencing, one that pushed the minimum term higher than it might otherwise have been. On the principle that violence chosen because of who a victim is should be answered with the fullest measure of the law, on January 30th, 2026, he was sentenced at the Old Bailey to life imprisonment with a minimum term of 37 years. And he was disqualified from driving for the rest of his life, a formality given the sentence, but a permanent statement all the same. No appeal has been reported. He is now serving that sentence, a man who turned a car into an instrument of violence against strangers on a morning meant for celebration, and who will spend nearly 4 decades behind bars before he can even ask to be considered for release. For the people who survived, and for Aidan Chapman's family, Christmas will never again arrive without the memory of what happened on those streets. A single night of violence had reached into the lives of families who had never met the man who caused it, and who would never fully understand why he had done it. Gilheeney tried to harm as many people as he could out in the open, in front of anyone who happened to be watching. The final case in this first half moves behind closed doors, into a home where a man tried to hide what he had done by destroying the very house around him. Clifton George. After he killed the woman he had shared his life with for a decade, he tried to erase what he had done by turning their home into rubble. He set off a gas explosion that tore through the house, and when rescuers found him afterward, lying in the garden, he told them plainly that he had killed her. Annabelle Rook was 46 years old and had spent her career on the side of vulnerable people. She was a charity worker who had helped co-found an organization supporting women fleeing domestic and sexual abuse. She was a mother of 2 grown sons. The cruel irony of what happened to her is difficult to set aside, because the danger she had devoted her working life to protecting other women from was the very thing that came for her inside her own home. Annabelle had been in a relationship with Clifton George, an electrician, for around 10 years. They lived together in Stoke Newington, in North London, in what had every outward appearance of a settled, long-term partnership. What that appearance concealed would only become clear in a courtroom long after it was too late to matter for Annabelle. On the night of June 16th, 2025, George fatally attacked her, inflicting wounds that some reporting placed at more than 30 in number. A post-mortem examination found evidence of a sustained and violent assault before the fatal injuries were caused, with signs consistent with being struck and with pressure to the neck. The findings pointed to an assault that had gone on over time, rather than ending in a single moment. Then, in the early hours of June 17th, George set off a gas explosion that ripped through the property, causing damage later estimated at around £400,000, apparently in an effort to destroy the evidence of what he had done. The blast was strong enough to threaten the whole street, turning a private crime into something that endangered his neighbors as well. When emergency crews reached the scene and found George in the garden, he told the paramedics that he had killed her. His own admission, spoken in the moments after the blast, would become one of the most damaging pieces of evidence against him. In the hours and days that followed, the account he gave began to shift. But that first statement at the scene stayed on the record and could not be walked back. Fire crews and investigators, meanwhile, had to work through the collapsed and burned remains of the house to establish what had happened inside it before the explosion, separating the destruction caused by the blast from the injuries that had come first. It was, in effect, a crime scene he had tried to erase, and one they had to piece back together from the rubble. How does a man convince himself that blowing up an entire house could somehow hide what he had already done? The courts were left to sort the truth from the wreckage. George pleaded guilty to manslaughter and to arson, admitting he had been reckless as to whether life was endangered. But he denied that what he had done amounted to murder. His argument was that he had not intended to kill, that it fell short of the highest charge. The whole case turned on that single word, intent, and the prosecution argued that the ferocity of the assault, followed by a calculated effort to blow the scene apart, pointed to a man who understood exactly what he had done and then tried to make it disappear. A jury rejected his account after weighing the nature and length of the attack against his claim. On June 3, 2026, he was convicted of murder at Snaresbrook Crown Court. 6 days later, on June 9, 2026, he was sentenced to life imprisonment with a minimum term of 23 years, a term that reflected both the brutality of the killing and the danger the explosion had created for everyone living nearby. No appeal has been reported. He is now serving that sentence. Annabelle Rook, a woman who had spent years helping others escape violence at home, lost her own life to it, and then had her home destroyed in an attempt to bury the truth. The attempt failed, undone in the end by his own words to the very people who had come to help. The organization she had helped build outlived her, still carrying on the work she believed in, while the man who took her life will spend more than 2 decades behind bars before he can even be considered for release. Her 2 sons, and the women her work had once sheltered, were left to carry a loss that carried its own bitter symmetry. The cases so far have moved from an online obsession to a family conspiracy, to cars turned into weapons, to a home reduced to ruin. The ones still ahead grow stranger yet. A body hidden inside concrete, an attack that none of the people who witnessed it could fully explain, and a cold case that waited more than 20 years before it finally reached a courtroom. Not subscribed yet? Now's the time, and if audio's more your thing, find us on Spotify too. You can click the link in our bio. Tony Davenport. For roughly 10 days, a woman did not leave the house she shared with her partner. She was kept there with little to sustain her beyond alcohol, and by the time her father came looking for her, she was already gone. What a courtroom would later piece together was a body carrying more than 100 separate injuries, and a man who insisted he had done nothing wrong. Stephanie Blundell was 41 years old. She had met Tony Davenport only about a year earlier, and the two of them had come together in painful circumstances, both receiving support for alcohol addiction at the time. For a while, that shared struggle looked like something that might bind them together rather than pull them apart. Instead, it became the backdrop to the last stretch of her life. They lived at Davenport's home on Canal Street in Chester, in the northwest of England. In the days before she died, Stephanie had not stepped outside that house at all. for something close to 10 days. And during that time, she was fed on little more than alcohol and ice lollies. Cut off from the ordinary rhythms of daily life, she grew steadily weaker inside those walls, and no one on the outside had a clear view of what was happening to her. On the morning of July 20th, 2025, her father, Philip Blundell, arrived and found her, and she was pronounced dead a short time later, shortly after 12:30 in the afternoon. Her father had come precisely because something felt wrong, and what he walked into was every parent's worst fear. When police came, Davenport was intoxicated and moving about the house, saying he thought she was dead. And when he was arrested, he insisted he had not done anything, even as blood was visible on his hands. In the confusion of that morning, he offered no clear account of how the woman he lived with had come to be so gravely hurt. His explanation, then and later, was that her drinking was to blame for everything that had happened to her. A post-mortem examination told a very different story. According to the Crown Prosecution Service and reporting on the case, Stephanie's body bore more than 100 injuries, a figure placed at around 102, including serious head trauma and fractures of a kind associated with pressure to the neck. Those were not the marks of one bad fall on one bad night. They were the record of harm inflicted repeatedly, over time, on a woman who had nowhere to go. How does a person come to be so badly hurt over so many days inside a home, with no one able to reach her before it was too late? That was the question at the heart of the trial. Davenport was tried at Chester Crown Court over roughly 4 weeks, across 16 days of evidence, before Mrs. Justice Karen Stein. Throughout, he maintained that he was not responsible, pointing again to Stephanie's alcoholism as the true cause of her death, and casting himself as a partner rather than an attacker. Prosecutors laid out a very different account of a controlling and violent household in which Stephanie had been steadily worn down until she could no longer protect herself. The jury did not accept his version. On February 25, 2026, he was convicted. 2 days later, on February 27th, Mrs. Justice Stein sentenced him to life imprisonment with a minimum term of 22 years. In her remarks, she found that Stephanie had died as a result of fierce, repeated, and sustained assaults, and that Davenport had kept her in that house offering her little but vodka. The judge noted the particular cruelty of confining a vulnerable person and depriving her of the most basic care. And she set the minimum term to reflect the sustained nature of what had been done. It was a description that captured not only a killing, but the slow closing in of a life around a woman who could not get herself out. No appeal has been reported. Davenport is now serving his life sentence. Stephanie Blundell, a woman who had been trying, like him, to get sober, instead spent the final part of her life confined to a house she could not leave, her condition worsening by the day. The people who loved her were left with the knowledge that help had been only a phone call away the entire time, and that the one person there to make that call never did. What had looked from the outside like a troubled relationship had, behind that closed door, become something far more dangerous. By the time anyone outside could see it clearly, Stephanie was already gone, and the chance to step in had long since passed. That case unfolded slowly over days, behind a door that stayed shut. The one that follows happened on the far side of the world in a matter of minutes, and left even the judge reaching for words, describing the circumstances as some of the most unusual he had ever seen. Mark Ludbrook. A man who normally relied on a wheelchair took an illicit drug to dull the pain of a rare neurological condition, and in the hours that followed, he behaved in ways no one around him could make sense of. He got up and walked unaided for more than an hour, and by the end of that night, a friend who had come to be with him, was dead, in circumstances a judge would describe as some of the most unusual he had ever encountered. Autumn Baker was 40 years old and a friend of Mark Ludbrook. She was the kind of person who stayed close during his difficult stretches, someone near enough to be there on a night when he was unwell. On the 3rd of August, 2023, she was at his home when everything came apart. She had no way of knowing that trying to help him would put her own life in danger. Ludbrook was 54 and lived in Melbourne, in the state of Victoria, in Australia. He had a rare neurological condition and used a wheelchair. And to manage his pain, he had taken an illicit dissociative drug known as PCE. It was a drug he had turned to for relief from a condition that made ordinary life a daily challenge, rather than something taken for pleasure. What followed was, by every account given in court, deeply strange, and it began well before any violence did. Though he normally could not walk, Ludbrook moved around his home unclothed for more than an hour, speaking and acting in ways that made little sense to those around him. He told his carer, a woman named Amber Davison, that she needed to be with him in order to save the animals. At some point, he took up a knife and turned it first on himself. The scene his carer and his friend were confronted with was frightening and hard to follow. A man in obvious crisis, holding a blade. When Baker tried to take it from him, in what appears to have been an attempt to protect him, he turned it on her instead. And she died. The central dispute in the case was never really about who had caused Baker's death. It was about whether Ludbrook could be held responsible for it. His defense argued that the drug had left him unaware of what he was doing, that he had not been conscious of his actions in any meaningful sense, and that a man in that state could not form the intent that murder requires. It was an unusual argument, and a difficult one, because it asked the jury to separate the act itself from the mind of the man who carried it out. Could someone be found guilty of murder if the substance in his body had stripped away his awareness of the world around him? The jury weighed that question and rejected the defense, concluding that he bore responsibility for what he had done. In the eyes of the law, taking the drug had been his own choice, and the consequences that flowed from it could not simply be set aside. On the 19th of February, 2026, a Supreme Court of Victoria jury found Mark Ludbrook guilty of murder. When it came to sentencing, on the 7th of May, 2026, Justice James Gorton, the same judge who had called the circumstances most unusual, found that Ludbrook's moral culpability was significantly moderated by his condition and his state of mind that night. That finding mattered a great deal, because it shaped the punishment. He handed down a sentence with a maximum of 19 years, along with a non-parole period that was reported as somewhere between about 12 and 14 years, depending on how the time he had already spent in custody was counted. It was a sentence that tried to hold two truths at once: that a woman had died at his hands, and that his mind had been clouded by the drug at the time. Ludbrook watched the sentencing by video link from prison. No appeal has been reported. The case sits in an uncomfortable space, one where a death was real and a life was lost, but where the court accepted that the man responsible had not been fully in command of himself when it happened. For Autumn Baker's family, that legal nuance offered little in the way of comfort. She had gone to the side of someone she cared about at a moment when he needed help, and she never came home. The strangeness of the case never quite lifted, and it left everyone involved grappling with a death that resisted any simple explanation. The jury had found its way to a verdict even through all of that uncertainty. But the questions the case raised did not disappear with it. The courts wrestled with how that death had come to happen at all. The next case leaves no such uncertainty about what was intended. only about the lengths a person will go to in order to keep a body from ever being found. Michael McClanahan. When officers went to check on a woman none of her family had heard from in days, they found her inside her own apartment, wrapped in plastic and partly set into concrete. Close by were the empty bags of mix and the bowls that had been used to pour it, and the man she had been in a relationship with was already sitting in a cell in another city, arrested for something else entirely. Sharon Turner was 44 years old and lived in Suitland, in Prince George's County, Maryland. She had been in a relationship with Michael McClanahan, but by the time of her death, she had already recognized the danger she was in and taken a formal step to guard against it, holding a protective order against him. Neighbors had heard a violent argument coming from the apartment in the days beforehand. Those two details, the order and the argument, would matter a great deal once investigators understood what they were dealing with. Turner was last seen alive around April 21st, 2025. 3 days later, on April 24th, a welfare check was carried out at her apartment on the 2300 block of Ewing Avenue, after someone realized they had not seen her since the 21st. 3 days had passed in which she made no calls and answered none, an ominous quiet for someone who was usually in touch. Inside, officers made the discovery that would come to define the case, her body wrapped in plastic and partially encased in concrete, with the empty concrete bags and mixing bowls still nearby. Investigators did not have to search hard for the truth of what had happened. Much of it was there in front of them, sealed into the floor of the home. It was a scene that spoke to planning and effort, to time taken after the killing to try to make the evidence disappear. This was not a killing followed by panic and flight alone. Someone had gone out, bought materials, and set to work turning the apartment into a hiding place. 2 days after that, on April 26th, the medical examiner ruled her death a homicide caused by blunt force trauma. By then, McClanahan was already in custody, though not for this. After the killing, he had fled in Turner's car, and the following day, he was arrested in Washington, in the District of Columbia, accused of stabbing someone at a Walmart, a separate matter that had put him behind bars before anyone had connected him to Turner at all. A chance arrest, on an unrelated charge, had already taken him off the street. For a time, the two cases sat separately in 2 different jurisdictions, a stabbing in the district and a missing woman in Maryland, until investigators drew the line that joined them. What drives a person to try so hard to conceal a death, even as the evidence of it sat waiting behind a door that anyone might have opened? Once the connection was made, the case moved through the system. McClanahan, already held in the District of Columbia on the unrelated arrest, was charged in Prince George's County and extradited to face the murder. The path from that Walmart arrest to a Maryland murder charge ran through the patient work of tying a man held in one city to a body found in another. His trial ended on July 9th, 2026, when a jury convicted him of second-degree murder and of disposing of a body in an unauthorized place. The county's state's attorney, Tara Jackson, announced the outcome. Second-degree murder carries a serious penalty in Maryland, and the additional count for concealing her body added to the total he faced. As of the making of this video, McClanahan has been convicted, but not yet sentenced. He faces up to 41 years in prison, and his sentencing is scheduled for October 6th, 2026, when the length of his time behind bars will finally be set. For now, the case stands as a conviction still waiting on its last chapter in a courtroom. Sharon Turner, a woman who had already seen the danger clearly enough to seek legal protection from the man in her life, was failed in the most final way imaginable. The order she had obtained, the piece of paper meant to keep him at a distance, had not been enough to keep her alive. Her family was left to absorb both the manner of her death and the cold, deliberate effort that had gone into hiding it. It is one thing to lose someone to violence. It is another to learn that the person responsible had spent hours trying to make certain she was never found. That effort to hide her, in the end, only underscored how deliberate and cold the crime had been. That was a killing only recently answered. Its sentence still months away. The next reaches back much further, to a woman found more than 20 years ago, and to a man whose name did not surface until the trail had seemed impossibly cold. DeMaurice Hunter. For more than 20 years, the death of a woman found in the trunk of her own car sat unresolved. One more name in a file that refused to close. When an answer finally arrived, it pointed to a man who was already serving more than a century in prison for other killings. He had taken lives across 2 states, and hers, it turned out, had been one of them the whole time. Teresa Ann Green was 38 years old and lived in the College Park area of Orlando, in Florida. The man who would take her life was not some stranger passing through, but a neighbor, someone from the same corner of the city she called home. She had a family, including a son who was still a child at the time. To the people around her, she was simply part of the everyday life of the place where she lived. On the 26th of May, 2002, Teresa was killed after a party. Prosecutors would later tell a jury that she had been strangled, and witnesses had seen her and the man responsible tumble down a staircase together that night. The following evening, on the 27th, her body was found in the trunk of her own car, left in a parking lot in Sanford, after he had reportedly enlisted a neighbor to help move the vehicle. The man behind it was DeMaurice Hunter, and what set his case apart was everything that surrounded it. Hunter was a serial killer. He had taken the life of an 18-year-old named Cesar Guzman back in January of 1985, and a woman named Evora Huntley in California in the same year Teresa died. 3 lives in 3 separate cases, tied back to the same man. By the time Florida was ready to try him for Teresa's death, he was already serving a sentence of 110 years to life for what he had done elsewhere. His record was not confined to one place or one year. It stretched across the country, from California to Florida, over the better part of 2 decades. How does a case stay cold for more than 2 decades when the person responsible was, for much of that time, already locked away for other crimes? The answer lay in the slow machinery of extradition and evidence moving across state lines. After Teresa's death, Hunter was arrested in Houston and extradited to California, where he was convicted of Evora Huntley's murder and sentenced in 2005 to that term of 110 years to life. It was not until 2015 that he was extradited to Florida to answer for Teresa. From there, the case was delayed again and again, held up first by the pandemic and then by a heart attack he suffered along the way. Years passed between the discovery of Teresa's body and the day a Florida jury would finally hear the full account of how she died. Finally, in April of 2026, a Florida jury convicted him of first-degree murder and theft in Teresa's death. On the 14th of April, that jury unanimously recommended the death penalty. A further hearing, held on the 1st of June, 2026, before Judge Lisa Munyon, was meant to help settle the question of his punishment. That kind of hearing gives both sides a final chance to put forward evidence and argument before a judge decides how heavily a life or a death should weigh. But that question has not yet been answered. As of the making of this video, no formal sentence has been imposed. The judge is not bound by the jury's recommendation, and the formal sentencing hearing is set for August 4th, 2026, when the choice between death and life will at last be made. Should a death sentence be handed down, it would begin a long process of automatic appeals under Florida law, one that could stretch on for years. For now, the outcome rests with the judge, and the gap between the two possible sentences could hardly be wider. Teresa's son, who was only a child when she was killed, grew up and stood in that courtroom as an adult, speaking about the mother he had lost. After more than 20 years, her name had finally been tied to the man responsible, even as the last word on his punishment remained just out of reach. For a family that had waited more than 2 decades for any answer at all, even a verdict without a final sentence was a kind of reckoning long deferred. The verdict could not give them back the years they had spent waiting, but it did, at last, give them a name to attach to their loss. In that case, a judge still holds the final decision in her hands. The last story we have is different again. A death that came not in a single violent burst, but slowly, over hours, in a hotel room by the sea, while help sat just a phone call away. Polly Murphy. A short seaside break for a birthday ended with one person walking out of a hotel room alone, and the other left, motionless behind her. It would be roughly 18 hours before she picked up a phone to call for help. And even when she did, she told the operator only that he might have a broken leg. James Self was 47 years old and from London. His health was already fragile, marked by severe liver disease and a long struggle with alcohol. He and Polly Murphy were described as partners and friends, and it was for her birthday that the two of them had traveled to the coast. He had no way of knowing that the trip would be his last. The setting was the Smuggler's Cove Hotel in Clacton-on-Sea in Essex, where the pair were staying for 3 days. What was meant to be a celebration became the setting for something far darker. On or around the 8th of November, 2023, over a period of roughly 2 hours, Murphy subjected Self to a sustained and violent assault. It went on long enough, and was severe enough, that it left him unable to get up on his own. Closed-circuit footage captured her leaving the hotel room alone, while he lay motionless inside. The cameras that recorded her movements would later help investigators reconstruct the timeline of that night and the long silence that followed. Rather than seek help, she waited. And the hours slipped past. It was about 18 hours before she finally called for an ambulance. And when she did, she described only a possible broken leg, saying nothing of what had really happened in that room. Those lost hours would become central to the case, because they were hours in which a man, who might have been helped, was instead left to deteriorate. This was not the first warning sign between them. A month before the trip, she had sent him a message threatening to hunt him down and end his life. And later, from his hospital bed, Self himself managed to describe the beating to a friend. It was a rare thing, a victim able to give an account of his own attack, and it carried real weight in the case that followed. In his own words, relayed to someone he trusted, was testimony the jury could not easily dismiss. What emerged over the course of the investigation was a picture of sustained abuse rather than a single lost temper. A relationship marked by control and cruelty well before that weekend by the sea. How does a person justify waiting the better part of a day to seek help for someone lying gravely injured only feet away? That was what the courts had to reckon with as Self's condition worsened. He was taken to hospital, and on the 21st of December, 2023, he died of multi-organ failure. A medical expert, Dr. Ahmed El-Sharkawi, testified that the injuries Self had suffered which included displaced fractured ribs and bruising to his face, had worsened his already poor health and directly caused his death. In other words, whatever part his existing illness played, it was the injuries inflicted on him that tipped his body into failure. The defense pointed to his liver disease and his drinking, arguing that his frailty complicated the question of what had truly killed him. It is a defense that surfaces often in cases involving vulnerable victims. The suggestion that a person was already so unwell that the violence cannot be blamed for the death. The jury here was not persuaded that any of it lifted the responsibility from Murphy. She had first been charged with grievous bodily harm. But once Self died, a murder charge was added in March of 2024. The change reflected a simple reality, that what had begun as an assault had ended a life. Her trial took place at Chelmsford Crown Court, beginning in November of 2025 and running for about 4 weeks, slowed at points by repeated changes in her legal representation. In late January of 2026, she was convicted of murder. On the 4th of February, 2026, she was sentenced to life imprisonment with a minimum term of 15 years. No appeal has been reported, and she is now serving that sentence. The minimum term means she will spend at least 15 years in prison before any question of release can even be raised. James Self, a man already fighting for his health, spent his final conscious hours injured and alone in a hotel room, waiting for help that a single phone call could have brought. And that came only when it was far too late to make any difference at all. His death stood as a reminder of how much can turn on one decision. The decision to pick up a phone, and of how devastating it can be when that decision is put off for hours. For a man whose health was already failing, those were hours he did not have to spare. That's where we'll leave things for today. Thanks for watching. Click here to see our next video.